I'm Kim. I'm Kim Elliott from the 4-7, and we are happy to host this evening's Tuesday Talk. Tonight, we're going to be talking about why CQE is key. And so we thank you for being here with us. We know that you will definitely be inspired by all that you'll hear tonight and hopefully find some information that you can use and also, of course, share with your networks and communities. Our host for tonight is the Regional Reentry Administrator, Mr. Daryl Graves. And so I'll go ahead, Daryl, and turn it over to you.
Thank you, Kim. So again, thanks to 4-7 for being our host this evening. And it's really exciting to see so many of you having joined us today to hear about this very important topic. We think that you will hear some things that will be enlightening for you and hopefully encouraging as well in the work that you do, or if you're someone who is interested in seeking a CQE. What you will hear tonight will help you, I think, learn a little bit more about some of the things that you may be already familiar with. We know that many of you are familiar with expungement and record sealing. What you're going to hear tonight will help you learn more about how the Certificate of Qualification for Employment is different from those other processes, what it is, what it isn't, and the advantages that come along with it. As always, we have tried to procure the very best expert that we have access to present tonight, and that in this case is in the person of Joann Sahl, who is the director of the Reentry Clinic at the University of Akron School of Law. So Joann will be joining us shortly, but just a couple of housekeeping things. Well, I'll remind you that you will be on mute during the session. If it makes your feed a little bit better and less complicated, you can turn your camera off if you like during the presentation. But we do want you to use the chat for questions. If you have questions, feel free to put them in the chat during the session, and we will respond to them as best we can. There will be time towards the end of the presentation for some more direct response to some of your questions. I will remind you, as we always do, that we don't, in this setting, we don't get into any detailed discussion of case-specific questions related to anyone. This is not the platform that we use for that. So, but you'll have plenty of opportunity to connect with the Office of Reentry at a later time. After this presentation, you will get the PowerPoint from our presenter. You will get several flyers that are available on our website. You'll get a CQE workbook that will help you with the process as well. And so we think that those two will all serve you very well in doing the work that you do or an application for CQE. So we're excited about all that. One last thing before we go to our presentation is we're going to launch a poll, and we're going to leave it up for about a minute. So please take a few seconds to respond to the poll. It helps us know who's here and why you're here and how we can serve you better as we continue our Tuesday Talk series. Okay, so I think we've given everyone an opportunity to respond to the poll. We appreciate that. We'll have one additional poll towards the end of our time together that will again take about a minute, and we'll ask you to respond to that one when we put that up as well. So before we get into our presentation, I'm going to ask my teammate, Dr. Roxanne Coy, to go ahead and drop a link in the chat for you. That will be a link to the DRC CQE webpage. So please take a moment to capture that link and make sure you use it and refer to it later. along with the other materials that we're going to send you post session. But right now, we'll go ahead and get to our presentation for the evening. Joann Sahl from the University of Akron School of Law. Joann?
Thank you so much. And I want to say thank you for your kind words as well, Daryl. I'm always excited to be able to talk about the CQE. I don't think there's enough conversation in Ohio about it. So it's wonderful when I have an opportunity to talk to new people. I see some faces on tonight that are some of my friends and people I know, and thanks for coming on. So I'm going to start by sharing my screen. I'm going to encourage you. I'm going to talk about two topics tonight. I'm going to talk about the CQE, and I'm also going to talk about the new expedited pardon project. So when I finish with the CQE, then I'm going to, I'll take a little break. And if you have questions about the CQE, we'll stop and we'll do that then. And then we'll go ahead and then we'll go into the expedited pardon. And if you have questions then, and I'm not sure why it will not let me do this. So, all right, we're going to go with what we have. So let's first start with, you know what, I'm going to stop sharing my screen because for some reason it won't let me go into presentation mode. It's being persnickety tonight.
Would you like Lisa to share the PowerPoint for you?
Yeah, it won't. Oh, here we go. It will let me do it now. There we go.
Okay.
It was being persnickety. It's going to stop being persnickety for me. So, okay. So here's the exciting stuff we're going to talk about tonight. The Certificate of Qualification for Employment. That is the very last time I'm going to use the official name. From this point forward, I'm going to call it the CQE. For all of us who do the work, that's what we call it. And I'm also going to talk about the new exciting pardon project that the governor's office began in 2019. Well, there we go. All right, so why am I going to talk about both of these things? For most of you on here, I'm not going to need to spend a lot of time on this slide. When someone has a criminal conviction and finishes their sentence, we all hope that that's the end of the sentence, but unfortunately, we have these persistent things in Ohio called collateral consequences. And those are all the non-criminal obstacles that come with your criminal sentence, which is inability to get a job, inability to get a professional license, you're trying to get housing, you're trying to volunteer. So we have remedies in Ohio to reduce or to eliminate those collateral consequences. And that's what I'm going to talk about tonight. All right. So I like to start with this because we have an outreach clinic at the University of Akron School of Law that we run once a month. I sit at the front table and I screen all the folks who come into my clinic, and everyone who comes says, I want to get an expungement. That's what I need. It's the be all and end all. So please, can you give me an expungement? So the first thing I want to say to you is we use the word expungement for our clinic, but it's not. What all of those folks are referring to is a court process that seals your criminal conviction. What that means is if the court grants the sealing, it removes your record from public view. It's still in a file in an office somewhere, but it just removes it from view. Okay, so I do a sealing and I'm like, great. I don't really need to do anything else. My future is bright. I'm not going to have any of those pesky collateral consequences. So it's a myth. It's a myth that court sealing, aka expungement, is going to give you everything you want. And here's why. Is just because your record is sealed from public view by the court doesn't mean that there aren't plenty of folks who can still see the sealed convictions. There are a number of people allowed by Ohio law to see sealed convictions. If you want to work for a vulnerable population, Board of Education, hospital, we do a lot of healthcare in our clinic. There are still folks who are going to be able to see your sealed convictions. So one of the reasons I like to do this presentation is because it's what I ask folks when they come to my clinic. What do you want to do? What do you want to be? Because that's really the first place you want to start, because then that'll help determine what you want to do. So if you happen to be working for an employer, want to work for an employer who's not going to see a sealed record, then sealing will work for you. but many, many, many people who come to our clinic, that's simply not the case. And I'm going to talk a little bit more about that. So what is this 3-letter CQE that we're all talking about tonight? So I like to flash this up on the screen first. It's a certificate issued by the Common Pleas Court. And we're going to talk about the process tonight, how you qualify, how it's granted, but this is what it looks like. That if you're given a CQE, you're going to be given this document that you can present to employers, licensing agencies, housing providers. But I want to be clear in this first couple of slides, it doesn't seal. That's not the purpose of the CQE. It doesn't seal your record from view, okay? So what does it do? Well, it does something that I think is just as good and actually better than sealing. So all of those things that prevent me, or jobs I can't get, or a professional license, or I want to volunteer somewhere, all of those obstacles because of my criminal convictions that stand in the way of my doing that are lifted by the CQE. Because what it does is it says that my criminal conviction is insufficient evidence. It's no longer enough evidence to show that I'm unfit for a license or employment. So practically how it happens is I have that certificate in my hand and I give it to an employer. The employer now is required to consider me on a case-by-case basis for that job. So the employer can't say, well, Joann Sahl, I'm sorry, you have that theft conviction from 10 years ago. We don't care about that CQE. We're not going to hire you. That's not what the law is. The law is very clear that the employer is required to accept a CQE. And the same thing for Ohio licensing agencies. They're required to accept a CQE, and they're now supposed to consider me on a case-by-case basis. The CQE opens the door, which is what we all hope for, right? Because if I have a chance to get in and sell myself to an employer, I'm going to have a much better chance of getting that job than if I just apply on paper and I don't have the CQE. So who's eligible? This is terrific. For those of you who know about sealing, you know, there are disqualifying convictions, and it's very complicated now, even though the statute has expanded. The CQE is terrific. There is not a conviction that disqualifies you from a CQE. Okay, so I could have, you know, beat my husband up, and maybe I wouldn't be eligible for a sealing, but I'd be eligible to apply for a CQE. You must have at least one Ohio offense. We have folks who come to us who only have out-of-state convictions or federal convictions only. They're currently not eligible to apply for a CQE. As long as you have one Ohio conviction, that's all that matters. And this third bullet point is terrific as well, because this is different than sealing too. Doesn't matter how many convictions you had. You can apply for CQE. I think we've done as many as 93 convictions. Doesn't matter. That's not the point of the CQE. It's not how many convictions you have. What the CQE does, though, is it limits those collateral consequences that can be lifted. So if I'm looking for a CQE to do one of the things on this list, it's not going to accomplish my purpose. So for example, if I'm on the sex offender registry, the CQE is not going to get me off the registry. If I'm seeking driving privileges because I don't have a license right now, I can't do that with the CQE. I want to be a prosecutor or a police officer. This is one of the few limitations in the statutes for employment, that a CQE, prosecutors' offices, police offices are not required, police departments are not required to accept a CQE. A health profession license, I'm not going to talk about this because it's a very narrow exception. I have a professional license suspension for non-payment of child support. If I hold a professional license, which I do as an attorney, and I don't pay my child support, the Ohio Supreme Court can suspend my license to practice law. A CQE will not get rid of that suspension for me. I want to run for public office, or I want to be an elector or juror before my sentence is served. So you see, It's very expansive in who can apply and very narrow in the limitations of what a CQE applies to. There are very, very few people who come to our clinic who we cannot do a CQE for. And usually it's just because of the waiting period, which I'm going to talk about next. So if you have a felony, you have to wait 1 year from the end of your sentence. And remember, if you are given community control, your sentence doesn't end until you finish your community control. So you have to finish all parts of your sentence before that 1 year time limit starts. Misdemeanor, it's 6 months, which is terrific. But I want to point out the exceptions because we see more people now falling into these exceptions. These are folks who do not have to wait 1 year or 6 months. So first of all, if you had your sentence reduced while you were serving time with the Ohio Department of Rehabilitation and Correction in prison, and you got to come home early, your sentence was reduced because you did one of the things on this list, you can apply immediately for a CQE. You don't have to wait for your sentence to end. And you'll see there are things that you would expect, that you did some sort of job training, you got your GED. And then I want to talk about the CAE for just a minute. So DRC has the equivalent of a CQE. That's the only time I'm going to be able to use 3 letters in the same sentence for 2 different things. And it's similar to the CQE. It gives you that lift of collateral consequences, and you can complete the CAE while you're in prison. And usually the only thing you'll need to do when you come home is finish your community service. So if any of you know folks who've recently been released or have been released from DRC and maybe did some of the programming and just need to finish their community service, I'd encourage you to talk with them about the CAE. All right, the next one, you were incarcerated in jail and the sheriff is recommending early application. Probably not, we're not going to see very many of those. But the next bullet point we are, which is I committed a misdemeanor, which you know are the lower level offenses in Ohio. Many of them don't even carry jail time. And all that happened to me when I was arrested is I received a citation to go to court or summons to appear at court and take care of my case. Those folks don't have to wait at all to apply for a CQE for that particular offense. They can apply right away because it's considered a misdemeanor that didn't carry any jail time. And then finally, the last bullet point, if it is someone who was on community control and they were terminated early from community control and they have a probation recommendation, they can apply right away. In Summit County, we have people in our reentry court. We have people in our Valor court. Those folks, if they complete their programming, they get their community control terminated early, and the probation department recommends that they can go ahead and apply for a CQE. Again, the purpose of the CQE is to get folks back to work. We want to get folks back to work because we know employment is the #1 reason to reduce recidivism. So we need folks to be able to go back to work to take care of themselves and their families. All right, the application process, it's an online application. I know they already dropped this link into the chat. This will take you directly to the DRC website and to the particular online application. You'll have to create an account once there, and you'll need an email address. And then you're going to complete the online application. And I think Daryl already mentioned to you, one of the materials you'll be receiving tonight is a wonderful workbook prepared by the Ohio Justice and Policy Center. It's a CQE handbook. It walks you through the entire process of completing that online application from beginning to end. When you finish the online application, then you will submit it electronically to DRC, and the group of awesome CQE people at DRC will then review the CQE application for completeness. And I can say from our own personal experience that normally happens within a week or 2. So it's terrific. There's not a big delay from DRC because, again, we want to get CQEs filed, granted, and get people back to work. Once that DRC determines it's complete, what's going to happen is that an email is going to be sent to the applicant at the email the applicant used to register on the CQE website. I will say this to all of you who are assisting people with their CQEs. Sometimes that email goes into the junk folder. I'll just say that. Sometimes it goes into the junk folder. So you want to be sure and alert your applicants to always be checking their emails to check all their email boxes to see if they receive that email. Because once they have the email, then they can print their application from that website and then go and file it with the Court of Common Pleas where they live. Now, for folks who live out of state but have an Ohio conviction, they can still apply for a CQE. They can file in any county where they have a conviction. So let's say I live in Indiana and I have a conviction in Summit County and Franklin County. I can complete my CQE, I can print it, and I can file it either in Summit or Franklin counties. It's a really terrific addition to the statute because before, out-of-state folks could not apply for a CQE for their state conviction. So what happens once the court receives the CQE application? And I really want to focus on this tonight because I think this distinguishes the CQE from every other remedy we have in Ohio. So once the court receives the CQE application, then the court is required to determine all the courts with convictions, okay? So if I complete my CQE application, I don't have to list, let's say I'm the person with 93 convictions. I can't list them all anyway because the application only has 11 lines. I really am required by the statute to list the convictions that are preventing me from the opportunity I want, okay? And if I don't list the other, 92, my CQE petition can't be denied. The statute is very clear about that. This is not a got me statute that, oh, you missed one, so the court's going to deny it. That is not the law. Because the statute places the requirement on the courts to go and find all the other convictions for the applicant, okay? I love this provision of the statute because doing other work where I have to find all those convictions, it can be really difficult. So the court's going to find all the other convictions and they're going to notify the prosecuting attorneys of the counties and the victims, if required by law, that the CQE application has been filed, okay? So all of that is taking place after you file your CQE application. Once that information comes back, then the court's going to determine whether to grant the CQE, okay? The court's going to look at the petition that the applicant filed. The court's going to look at the applicant's criminal history, except the newest change to the statute is this. If I had my record sealed or expunged, the court may not consider that anymore, that record, in determining whether I'm eligible for a CQE. I love this addition to the statute as well. The court's going to look at anything that the prosecutor or the victim might have submitted. The court's now required to look at the military service record if the applicant is a veteran. In addition, they're to look at whether the crimes that were committed were they in any way related to emotional, mental, or physical condition traced to their military history. So the legislature has really recognized the importance of giving some substance to what our folks in the military have done for us, have done for us in serving in the military. And then finally, the court can look at any other relevant evidence. So this is the first slide that I always tell my CQE folks, so keep it in mind. This is an exhaustive investigation that the court is doing in order to determine whether you're eligible for a CQE. The sealing does not have this kind of investigation, okay? This type of investigation is not required. So once the court finishes the investigation, then it can determine whether it wants to issue the CQE if, number one, it will materially assist the applicant in obtaining an occupational license, and it should also say, or employment. Okay, and I would hope that to be the case. And these are the questions that are actually on the CQE application. So the applicant's going to already have to answer this question. Number two, my most hated question in the statute, that the applicant has a substantial need for a CQE to live a law-abiding life. I think it's a very difficult question because all of our folks are already living a law-abiding life. But what I advise people to do who are completing the application is to say, I'm already live a law-abiding life, and the CQE will allow me to continue to live a law-abiding life. And then finally, look at bullet point number 3. The court has to determine if granting the CQE will pose an unreasonable risk to the safety of the public or the individual. Okay, so let's just think about what the court has already done. They've done this, the court's done this exhaustive investigation and contacted pretty much anybody who would have anything to say about whether this person's a good person or should get a CQE. And then number 3, to grant the CQE, a court, after that exhaustive investigation, is determining whether I, as the applicant, pose an unreasonable risk to the safety of the public or an individual. I say to the employers all the time, you're risk averse. So the court has already done the investigation for you, right? An exhaustive investigation, and the court has determined that I, as the applicant, am not going to be a risk to you, to the general public. Again, we are not getting that with sealing. The difficulty here is explaining to our CQE applicants the importance of explaining this to employers. And I say to employers, you know what? If you want somebody else to do all your background work for you, send the folks to get a CQE, okay? So here are some other changes to the law that I think have been a sea change to helping get more CQE applications granted. Number 1, if it's been 3 years since your felony or 1 year since the misdemeanor, you are rebuttably presumed to be eligible for the CQE, which means that when the court receives that application, the court must begin its process with already deciding that you're going to be granted the CQE. And there has to be a good amount of evidence, which is what my second bullet point is, to overcome that starting point. And it can't be minimal, and it can't just be, well, we don't think it's a good idea. It has to be really strong evidence in order to overcome that presumption. So if you're counseling folks about why would I want to apply for a CQE, this law change has really made the difference. I think it's really, really freed up the courts to grant the CQE. And then the final bullet point here, the CQE will only be revoked if the individual commits a new felony. And I know that employers ask me this question, how will we know? DRC posts it on its website, so you'll know. It's transparency, but you know, it doesn't happen often, but it can happen if they commit another felony, not a misdemeanor. All right, so I've talked through the process, and I'm going to circle back again to this point, which is, why on earth would I want to take the time to do the 16-page application? What's that CQE going to give for me? Again, I still have the idea that the sealing is going to be the be all and end all. Well, here's why. When the CQE statute was enacted, the legislature really thought about this and said, how can we entice employers to hire people with criminal convictions? Not just having the CQE, but why? And here's why, is employers don't hire people with criminal convictions because they're worried something's going to happen, right? They're worried something's going to happen to one of their clients or their customers, and they don't want to get sued. They're really worried about being sued. And so the legislature said, aha, so let's deal with that issue, which is, if something happens, you hire somebody with a CQE, and something happens and you get sued for a negligent hiring claim, you can raise the CQE as a defense to being sued. Big change. It really helps in terms of convincing employers why you want to hire someone with the CQE. And then, of course, we've talked about this through the beginning part of my presentation up till now, which is, it's a benefit to the applicant. It's a benefit to me if I'm an applicant. I can go into that opportunity, that job, or the licensing agency and sell myself and say, look at all the work the court did. They did this. They talked to all the prosecutors. They contacted all the courts. You know, they found I wasn't a risk, and they granted my CQE. So why do you, employer and licensing board, have any issues with hiring me? So again, for all of you who are working with folks who have a CQE, this is always the sticking point, because it's hard for our clients to sell themselves. It really is, because so many doors have been closed for them. So this is probably the most important piece you can do with them. Not only assisting them with filling out the CQE application, but once granted, talking through with them how they sell themselves to the employers and why the CQE is important. Because I'll tell you, there are just a lot of employers who don't know about the CQE. And once I explain it to them, they're really excited about it. But having our clients or folks you work with explain it to an employer can be intimidating. We do have some sheets at Akron, which I'll email to Daryl after the presentation is over, that we hand out to folks. And I think the Ohio Justice and Policy Center has some stuff on its website as well. But we've got to get our folks educating employers and also selling themselves once they get the CQE. So here's my next favorite part of my presentation. So I've been doing this work a very long time, ever since the statute was enacted. And when the CQE statute was enacted, the legislature was clear, which was Ohio licensing boards, you're required to accept the CQE. We're not accepting it. You're required to accept it. And that means you're supposed to make this case-by-case determination. So, 8-9 years go by, it's not happening. I actually did an appeal in a case where, and I won't tell you what board it was, simply didn't accept my client's CQEs, as if it never happened. So the legislature decided enough was enough. And they made some changes where they said, we really, really mean it this time, okay? So I want to talk you through this. I also hope that you will write down these statutes. You can just Google them. It's 9.78. If you just put Ohio Revised Code 9.78 and Ohio Revised Code 9.79, anyone who's doing this work and helping folks who want to get a license, and I'm telling you, we have so many licensing boards in Ohio. We have so many folks come to our clinic. Like, we see a lot of HVAC people. We have a lot of healthcare. We have to educate our folks about what the law is. So number one, with the change in the law, and this one's a little bit older, any of our folks who have criminal convictions may always ask the licensing board to which they're applying whether their criminal conviction is going to be an obstacle for their license. And that's notwithstanding whether they have a CQE or not. And the licensing board is required to respond back to them, and they're supposed to respond back in 30 days. Now, the statute also says the licensing board can charge you to do that. So that's really for a small group of people with criminal convictions who might not want to do the CQE. But let's talk about when the legislature said we really, really mean it, what they really, really mean. So for years and years, the licensing boards in Ohio were all over the place. We would have convictions that were a 5-year disqualification for the license, or 22 years, or 75. And we also had this, good moral conduct, or if you were of bad character, a lot of licensing boards had that. So in order to make this process easier, the legislature said, we have to stop this. We just have to stop this nonsense. And so if you look at the statute sets out what offenses are disqualifying by what year period. So what are disqualified by 5-year wait periods? What do you have to wait 10 years for? And what are could be permanently disqualifying? So that was a big step forward. But here's the important part for the CQE. None of those time periods matter when you have a CQE. Okay. So if I'm applying for a license and there's something, my convictions, and my client who I represented had a permanently disqualifying offense, he also had the good moral conduct, they still have to accept the CQE. Okay. They still have to consider you on a case-by-case basis, but it's more than that now. The boards have to put on their website information about the CQE. They have to put on all their applications that you can apply for a CQE if you have a criminal record. They now have to disclose, licenses denied because of criminal convictions, licenses granted based upon the criminal convictions. It is a much more transparent process for all of our folks who are, I know, are being denied professional licenses who held CQEs. So again, for your folks who are looking to get a professional license, because, folks will come to me and they're like, I don't have any hope. I want to be a paramedic. I want to be an EMT. And I have this criminal conviction, and they're not even going to look at me. They've told me that. Or a lot of what I see are nurse. I'm not going to be able to do a nursing license. Not true. Not true. They need to get themselves to CQE, and they need to be able to use the CQE with the licensing board. Okay. So I really wanted to talk about this because this has been a big change in the last 10 years. And I think it is a very positive change for all of our folks who are looking not only to get an employment, but to get an employment with professional license, because from my perspective, a good number of those folks are going to have higher wage, right? And folks who come to my clinic, they're almost all employed. They're just underemployed. And so we really need to push the professional licenses to help our folks get those. All right. So then this is what folks always say to me at the front table. Every once in a while, I have a CQE client come in who already got a CQE, and they'll just sit with me at the front table and help with this. It's like, yeah, I'm not going to do that. First, they'll come to my clinic and they'll be like, well, how long is this going to take? And I'd be like, well, probably an hour. So, well, is it really worth it? Because I don't really think I'm going to do it. So thanks to Roxanne Coey at DRC and the DRC 2021 report, as of 2021, we had 1,488 CQEs granted. And I love this list, love it, because it gives you an example of all of the folks who are looking for these opportunities and didn't have the opportunities before the CQE. Love it. I mean, we see a lot of people on the bottom, like on the last thing on the second column, a lot of people doing general employment, but a lot of people, and these are just some examples. And as I've said probably 3 times now, a lot of healthcare. We see a lot of people in the healthcare field. So I wanted to put this up there to really dispel the myth of, I'm not going to get a CQE and I'm not going to get a job. I'm not going to be able to do what I want to do. Okay, I'm going to take a break here for a few minutes and see if we have questions. So whoever's monitoring the chat for me, see if we have any CQE questions before I move on.
Yes, Joann, thank you very much. Very informative, as we knew it would be. I see a few questions here in the chat that we'd like for you to address for our audience. And the first one is from Michelle, and the question is there a time frame for completing each step of the CQE process?
So the statute has a requirement about how long the court's supposed to complete or when the court's supposed to rule, but that's after the court completes its investigation. So if the court investigation takes several months, so there's not a specific time frame of, DRC has to review it in 14 days and the court has to rule within 30 days. So I can only talk about my experience, but I did a presentation a couple of weeks ago where others' experiences are not the same. It tends to be, and maybe Roxanne can chime in on this too. She can give a better idea of what it looks like around the state in terms of the time frame. Our court is very quick in Summit County. And I think there's some other counties that's the same way. I know for our rural counties that don't see as many CQE applications, it could take a little bit longer. I'm just going to say to those of you, it's worth the wait. It's worth the wait.
Joanne, there's not very many that are happening within 30 days. It's scattered. It does happen. Most of them are 60 to 90.
And you know, because the statute says they only have to rule in 30 days after the investigation's complete, right? So it's not, once I get the CQE, I have to rule within 30 days. But still, when you think about 60 or 90 days, I'll be honest, for our sealings, our expungements, they take longer than that.
Mhm.
So many times at our clinic, and I'm going to talk about this at the end, we'll do more than one thing for someone. It's not unusual for us to do the expungement or sealing with the CQE.
Thank you. So another question is from Christina Dungan, and Christina asked, does the CQE apply for those with felonies for possession of substances?
You bet. You bet.
Okay.
Remember, there's no conviction that disqualifies you from a CQE. That's what's so terrific.
All right. And then a question from Sarah. If a person was convicted of a felony and served their sentence in prison that was over a year and is on parole, do they still need to wait a year to apply?
If they received a sentence reduction, they came home early based upon that list I put up, they can apply right away. If not, they have to wait till their parole is finished and 1 year after their parole.
Okay. Good, thank you. And then the last thing I'm seeing here, Joanne, is a question that we always get. Does the CQE help with, excuse me, does it help with finding some place to live, or is it only specifically for employment?
So I happen to be lucky and live in a county where they grant CQEs for housing. So here's what I'm going to say to you. This is going to be my advice. Our subsidized housing landlords accept CQEs as proof of rehabilitation. So let me just say that. We haven't had good experience with private landlords, but certainly with like our housing authority. So we add it to our application. So if someone comes in and does a CQE application for employment and they want to do one for housing as well, we'll add that as a second reason. But we definitely do CQE applications for housing. So I don't know, and maybe Roxanne, you can talk about this too, if there are others who have the same experience we do in Summit County. Do you know?
Only anecdotally, most of them have been Summit County. I haven't really had somebody share specifically outside of that.
Yeah. Okay. But my position on anytime trying something, why not try it? Right? What's the worst thing that can happen? The court can say no.
Right.
But if the court says yes, terrific.
Right. Okay. Thanks, Joanne. Thanks, Roxanne. I'm not seeing any other questions, and I'm not seeing any raised hands right now. So if you want to go ahead with the next portion of your presentation.
Okay, so this is the other exciting thing that I get to talk about tonight. For the governor of Ohio can grant pardons, and the Constitution allows the governor to grant pardons. And I've been doing pardon work for a long time, but it would take a long time. It could take 2, 3, 4 years from application to when the governor pardons someone, and that's not really helping you if you want to get a job, or you want to get a license, or you want to get housing. So Governor DeWine in December of 2019 decided that he was going to start a project that would speed up pardons for certain categories of cases. Okay, any of you listening tonight, if you know folks who are eligible, please have them apply, okay? So what does it look like? Well, it has to, in order for you to be eligible for the project, it has to be 10 years since the end of your last sentence or your last conviction. These are factors we can't change. This is just what the governor is requiring for this program. All fines and restitutions have to be paid, or we can make arrangements for you to pay it, or we can ask the court to forgive it. You have to be employed or have a reason that you're not working. So we do, folks, people who are disabled, we do pardons for those folks. You have to have some community service or volunteer work, okay? And that's not community service ordered by the court. That's things that you're doing in your community. And you can't have any of the disqualifying offenses. The list is really narrow. You might think it's broad, but I'm telling you, having done this work for a long time, it's very narrow. These are the only offenses that would keep you out of the project. And they're probably what you would expect. Aggravated murder and murder. Actually, it's really anything involving the death of another, because that also includes voluntary manslaughter, involuntary manslaughter. Your sexual offenses, kidnapping, felony child endangering, not misdemeanor child endangering, terrorism, and domestic violence. And I'm sorry, I wish we could do it for domestic violence. I really do, but this is the governor's requirement. So, and that means even if you were charged with domestic violence, but you pled to something else, you won't be eligible for the project, okay? So very, very narrow category of cases. So what do you need to do? This is the website. The application is on here. You'll submit an initial application to Akron. We screen all the candidates. The instructions to complete the application and the forms are on the website. There's actually a how-to video if you need assistance with doing that. If we have some community agencies on tonight that want to advertise the project, there are some terrific flyers on there as well that you can use as you want to try to advertise. And if you want to hand them out to the folks that you serve, we need to get people in this project. It's a terrific, terrific opportunity. And I know there are more folks out there who are eligible. We're at almost 400 applications since the process started. So we've seen a lot of people, but I'm guessing there are just tons and tons more. Once you complete the application and it's sent to Akron, one of my students is going to conduct a background check to make sure you're eligible. And then my student is going to call and interview you. They're going to call and talk to you about your criminal convictions and all the terrific things that you've done since those convictions and why you want a pardon. Okay. Once that's finished, then we're going to vote to decide whether you're going to be accepted into the project. And the great thing about this project is you're going to get free legal help. You will be assigned to one of the law school partners who is doing the pardon applications, and we will assist you with completing the pardon application, the whole packet that goes to the Ohio Parole Board. The Ohio Parole Board is involved because in Ohio, before the governor can grant a pardon, the Parole Board has to conduct the investigation and hold any hearing. So the parole board will get the application, you'll be scheduled for a hearing, and then once the parole board makes its recommendation, because that's what the board does, is it only makes a recommendation, the governor has the ultimate decision, then it goes to the governor for his decision. So what's the great thing about this pardon? You've already talked to me about sealing and CQE. I mean, how many more things do you want to pile on me tonight? Well, here's why, is we have folks who come to get a pardon, because maybe, just maybe, you would like the state of Ohio to forgive you for your offenses. And that's what it is. It's a forgiveness. It's not a placing you back in the same position as if you never had a conviction, but it's a forgiveness. It's the governor of Ohio saying that you're being forgiven. And it removes all of the disabilities, again, like a CQE does. But here is the best thing, folks. If you are someone who is interested in sealing your criminal record, but you've not been able to do it because you have disqualifying offenses under the sealing statute, that doesn't matter for a pardon. If the governor grants you an unconditional pardon, the law changed last year, your record will be sealed. So I talk to folks all the time who might have, those offenses, for example, F1s and F2s, or more than one F3, who to this point in time, they haven't been able to get their record sealed. You can accomplish that, not only get a pardon, but have your record sealed with the new expedited pardon. So, and so then people say to me, well, this is just like the CQE. I'm not going to go to all that bother. The governor really only grants pardons for his own friends or people he knows. And so why would I apply? Well, here's the reason why. We have already had 32 pardons in the pardon project since it began, which doesn't sound like a lot, but it's a lot. And we have more folks who've had favorable recommendations from the board who are waiting on a governor decision. So it is a really successful way of dealing with your criminal convictions. So if you're someone or you know someone that has spent 10 years, they don't have one of those disqualifying offenses, just go check out the website. All the instructions are on the website, what you need to do. Okay, so my final points tonight, and then I'll open it up for some questions as we end here. Ohio, we are really fortunate to live in Ohio where we have a buffet of remedies available to people. There are states that don't have the same remedies that we do. So I always say to my clients, please don't labor under all of those burdens you're carrying from your criminal conviction. We need to figure out what's going to help you. Maybe it's court sealing. Maybe that's going to get you what you want. Or as we talked about, maybe court sealing's not going to be enough. And then maybe you're going to want to do a CQE. Or maybe you want to consider a pardon. I will tell you that we have folks who do all three. It's not unusual for us to have folks who have gone through the process with us of sealing, CQE, and now we're assisting them with the expedited pardon. Okay, so that concludes my formal presentation. So Daryl, let's see if we have any other questions I can answer before we end.
Joann, one of the questions that we get a lot is the fees for filing with the CQE in the court. And what it seems to me is that typically it's $50, but not every court adheres to that. Is that correct?
That's correct. So the statute says $50. Not every court adheres to it. If you can't afford to file your CQE, you can't afford the filing fee, you can always ask the court to waive the filing fees. Now, I happen to live in a county where they won't do that, but you can always, if you can't afford it, you can ask the clerk whether you can file an affidavit to waive the filing fee. And that was a good question, Roxanne, because I didn't talk about that.
All right, I am not seeing any other questions in the chat. Does anyone have a question that you want Joann to address about CQE, about the difference between CQE and sealing and expungement or anything? I think we've had a lot of education here in the past few minutes.
And so, Daryl, let me just chime in real quick about that.
Sure.
One of the reasons that I don't call the sealing statute as sealing is because we do have an expungement statute in Ohio that actually destroys your record for two circumstances. Number one is if you were charged with carrying a handgun in your car before 2011, the law changed about that and it's no longer a criminal offense. Also, I understand with the new CCW law that there's been some changes and there's some expungement provisions perhaps with that. But the biggest one we see in our clinic is if your criminal conviction is as a result of being the victim of human trafficking, and that sex trafficking, that you were compelled into prostitution or soliciting, you might be eligible to have your criminal record destroyed. So that's why it's so important for the language with me, is because an expungement means destruction, and we have that remedy in Ohio, but it's not court sealing.
Okay, thank you. I do see one other question here from Sarah, and it's, is the pardon application, is that process free or is there a cost?
Yes, it's free.
Yeah.
It's free.
Okay, great. Roxanne, did you have anything else that we want to reiterate or that we want a little bit more information on? I do have one closing thought for folks, but I want to make sure we have time. We always make sure we allot plenty of time for questions. Okay. So if there's not any other questions, we'll actually do a poll, and then I'll have one closing comment before we conclude for the evening. So we can go ahead and launch that poll, and we'll ask you to take a minute to respond to that.
While they're doing that, there's another question. If someone's not approved for the pardon, should they try and apply again?
I'm sorry, Roxanne, I didn't hear the full question.
If someone is not approved for the pardon, should they try and apply again?
So if I want to talk about this because this has become a problem. If you have received the decision from the Ohio Parole Board, that is not the end of the project. The governor still, or the end of the pardon, the governor still has to decide. If you get a denial from the governor, you have to wait 2 years to reapply for a pardon.
Okay. And then one other question I'm seeing from start to finish. Oh, it just moved on me. From start to finish, how long does the pardon process take?
It's been running about a year from full application to decision, which is, it doesn't seem quick, but it is quick because there's a lot of work involved in doing the pardon.
And I think those have had a chance to respond to the poll. I do see one other question. And the question is, if someone has been granted a pardon, will that pardon be revoked if they have a new conviction?
No, once the pardon's granted, it can't be revoked. You just obviously won't be pardoned for the new conviction. That's all. I mean, you'd have to reapply to get the new conviction pardon, but the pardon will not be revoked.
Okay. Okay, great, thanks. All
Gosh,
right.
Joann, as always, phenomenal.
Yes. I'm not seeing any other questions. So the last thing that I just want to share with everyone, again, we appreciate everyone being here on a Tuesday evening in midsummer. We know you could have made a choice to be someplace else, but this is really important. We have really dedicated ourselves more than ever to making sure that people have the information about CQEs. And so the last thing I want to share with you is just that we are trying to build sort of a network of CQE support around the state. And that's why we really wanted you to be here today. We're trying to make sure that people, everybody who is eligible has an opportunity, has the information, and has support in their community to complete the application process. So we strongly encourage you, if you are trying to assist someone, or if you need to apply or want to apply, please use the materials that we're going to send to you. I'm going to send them out. Actually, as soon as we're done here tonight, you'll get an email with all the things that we talked about, either that Joann reviewed or referenced during the presentation. And if you have any questions, please reach out to us here at DRC. My email will be included, and the Office of Reentry email will be included. So please reach out to us for assistance, and we will do our best to help you help other folks in the community, or to help people get the process completed. And if we have questions that we're a little stumped by, we'll ask Joann to help us. And she has been very diligent and very generous with her time and effort to help educate us on the process, so that we can make sure that all Ohioans who have a need for a CQE have the opportunity to make the application process and have themselves considered effectively and fairly for employment around our state. So again, we appreciate you being here. Please reach out if you have any other questions about this topic, or any other question that you have about any Tuesday Talks topic that we have. Our next Tuesday Talks is scheduled for Tuesday, September 13th at the same time, 6 p.m. So look for more information about that in the coming month. And we hope to see you there. And as always, share all the information with anyone in your network that might find it useful. So we appreciate your time, and everyone have a good afternoon.